Hi, this video is about transportation law, and the subtopic that we are going to cover are common carriers, their definition and classification and distinctions with other kinds, and vigilance over goods as an obligation of common carriers. So let's start with general provision, subsection 1. What is a common carrier? This is the most basic question, and this is very important. A common carrier is a person or a corporation or firm or association in the business of transporting goods or passengers. Pause muna, or both. No? So, tandaan natin, it is a person, corporation. In other words, it is an entity. So, just a recall in our civil law, there is natural and there is juridical entity. So it can be an individual or a human being or a corporation or an artificial being. And then it is not a vehicle. So hindi siya yung hindi siya yung bus mismo, hindi siya yung motor, hindi siya yung kasasakyan, yung jeep. It is the person. So it's very important kasi lalabas yan mamaya sa cases. And then ano yung ginagawa niya? Nasa business siya. Businessman siya. Business-minded, entrepreneurial. And ano yung business niya? To transport goods or people or both. So that's the business. And then, ano yung means? Walang outer space land, sea, and air lang. So I don't think it covers the outer space or under the land. It's only land, sea, and air. And then offering services to the public for compensation. So since it is a business, so it's correlatively linked to holding out to the public kasi wala ka namang business pag hindi ka nagpa-publicize nagma-market. Okay? So that's the definition of common carrier. And of course, for compensation, kasi nga, business siya. So, one of the definitions or elements there is offering business to the public. So, what does the public mean? So, in the case of ANCAS, in the ANCAS case, or FTFRB versus Valenzuela, the public there does not always mean indefinite public, or for example, if the Philippines, not really the whole population of the Philippines, but the court said that it could refer to the narrow segment of the population. Next question, is ownership of the vehicle required for a person to be considered a common carrier? The answer is no. As long as an entity holds itself to the public for transport and for compensation, it is a common carrier. So the most important element there is holding out to the public. In other words, it's marketing. It is offering its services to the public. And in the ANCAS case, it could also even refer to the app that once the motorcycle drivers open or become online, it already becomes available to an indiscriminate members of the public. In other words, wala silang pinipiling person, target person, but anyone can hire them. So that's the public there. And it does not require that it is owned by the driver or the common carrier itself, because it can also be driven or owned by another person. So, it's not an excuse na hindi mo pagmamayari ang vehicle for you to be considered a common carrier. Question, what is the best test to determine whether a person is a common carrier? So, again, it is the quality of holding out to the public that it is engaged in such business. So, the question, is it open for use of the public? So it's the quantity and extent is not relevant. So kahit konti lang yan, for example, in one case, kahit students lang yan yung target, that's already considered the public. And extent is not relevant. So again, even sa city lang yan, sa barangay lang yan, if it's public, then it's a common carrier. Because in De Guzman versus CA, it says the law makes distinction between one who has it for principal activity or an ancillary activity. Sorry, the term is the law does not make a distinction. Carriage may be episodic or unscheduled or limited. So it doesn't necessarily have to be continuous, like 24/7. It can be episodic, such as like once a week or 3 times a week. So the common carrier is distinct from the vehicle. The former is a person and the latter is property. So again, the common carrier is not the plane, it's not the ship, it's not the jeepney. The common carrier is the person. It is the business corporation. It is the owner individual or the owner entity, the owner association. Question: are school buses common carrier? In one case, the court said yes despite of the limited clientele. So sabi natin kanina, kahit yung target public audience mo are members or students of a school, they operate as a common carrier because they hold themselves out as a ready transportation to the students of a school which is limited in scope, where they operate for compensation. So a school bus is a common carrier in that case. Another, what are examples of common carriers? So barge operator, passenger jeepney, bus such as bus or taxi companies, vessels in inter-island shipping, or like in our case here, the fast crafts, the roros, and then cargo truck to transport goods for a fee. So next question, are travel agencies common carrier? So using the elements, so does a travel agency, question, does it hold out to the public? Yes, but the question is the holding out in relation to transporting passengers or cargoes or both? The answer is no, because it merely arranges its clients for air transportation usually. So when you book a ticket in a travel agency, they are not a common carrier because what they do is only go to the portal of, let's say, a specific airline, and they book a ticket for you in exchange of a compensation to them or profit to them. Next question, what are private carriers? Those that do not hold themselves out to the public as ready to act for all desire to all who desire his services. They only undertake to transport persons or property by special arrangement only from one destination to another, either gratuitously or for hire. So that the only difference here is they do not hold themselves out to the public. So they can only have the special arrangement for one client, no, for one passenger. So, what are the primary and suppletory laws governing certain transportation contracts? So, just a quick recap. For common carriers in land, it's the new civil code, and the suppletory law is the Code of Commerce. For private carriers, nag-iba siya. It's the Code of Commerce, ang primary law, and then the suppletory law is the new civil code. For air transportation, it's still the new civil code, same as common carriers sa land. And then from PH, so if PH is one of the itineraries, let's say it's an international flight, then it is governed primarily by treaties, agreements, or Montreal Convention. Inter-island, let's say fast crafts, Cebu to Leyte, Cebu to Dagupan, so that's governed by the new civil code and suppletarily governed by the Code of Commerce, same as the air transportation. From foreign port to PH port, it's governed by the new civil code because of the law that it shall be governed by the place of the destination or by the law of the destination place. How about from Philippine port to foreign? It's the law of the country of the destination. Now, let's go to examples of private carriers. Number one is bareboat charter. We will know later kung ano yung bareboat charter. Funeral car. Okay, why? Because a funeral car does not hold itself to the public, but it only caters or services a specific clientele, and that is under the plan, let's say, of a specific death care company. Next, exclusive hauler of products for one company only. Next question, what are the main distinctions between private and common carriers? Number one is the holding out. So the public or the common carrier holds out its services to the public while the private carriers do not. So there's the line there. So for example, like uso ngayon yung mga joy rides, no? So can you consider that private or common carrier? Meron na ngayong mga private group chats wherein people offer themselves to members of that group chat. So is that public. They post sa social media their services. So can you consider that a private carrier or a common carrier? And then another is, this is the obligation. Pertaining to obligation, the common carrier is obliged to observe extraordinary diligence, while a private carrier is only required to exercise ordinary diligence. So may mga corresponding presumptions yan later that we will know. Psalm 121, 7 to 8, the Lord will keep you from all harm. He will watch over your life. The Lord will watch over your coming and going both now and forevermore. Tandaan natin that it is even when we just transport ourselves through common carriers or otherwise, we are still under the mercy of the protection. So it's always, we have to remember that. Next, when may a common carrier be converted to a private carrier by stipulation? So, meron possibility, di ba, from common carrier, uh, he is obliged extraordinarily in the case of bareboat or demise charter. Ang bareboat kasi is when the ship owner does away with its own vessel and the crew, another party controls a particular voyage. So for example, ako yung may-ari ng ship or ng barko, I will lend my vessel, okay, um, to another person, and he is the one who will put his own ship captains and crew on my boat. So that is a bareboat charter. So that is now converted to a private carrier. But if I retain my own ship owner or my crew, then that is merely a service of a public or a common carrier. Bar 1984, another common uh, distinction, or I mean, when may a common carrier um, convert to a private carrier? When a bus totally agrees that it will be used for a single or by a single party. So like mga cases ng mga private for hire or for private use, no, na gagamitin siya ng like isang family outing or gamitin siya ng isang company outing. So that is a conversion from common carrier to private carrier. Next, what is a bareboat or demise charter in other words? It is an arrangement for the chartering or hiring of a ship or both for which no crew or provisions are included as part of the agreement. Instead, the people who rent the vessel from the owner are responsible for taking care of such things. Next, what governs rights and obligations for private and public or common carriers? So let's start with private carriers. They are governed by the parties' stipulations. So let's say a BPO hires a van. So that van, it transports the BPO employees. So what governs them is not the civil code primarily, but the stipulations between them. For common carriers, of course, by law, and then the terms and contract of carriage. Another question that is common now, what are transportation network companies? Uso na to ngayon because of the advent of mobile phones. TNCs or transportation network companies are organizations that provide pre-arranged transportation services for compensation using an online enabled application. So these are arrangers of transportation. So just imagine Angkas, Grab, or Uber, they merely arrange you as a passenger and connect you to an available rider or to an available driver by technology. That is in the case of Angkas. So examples as stated here, Grab, Uber, Angkas. Are TNCs common carriers? Well, in the case of Angkas or LTFRB, uh, it could be implied that they are not common carriers because they merely link party drivers and passengers, and they do not transport passengers or cargoes. Again, we have to remember that common carriers are in the business of carrying cargoes, passengers, or both. So TNCs only link you to a common carrier. So it can be compared to a travel agency, as what we have said a while ago, that the primary duty is only to arrange a trip, or just like a freight forwarder which only accepts your cargo and uses another common carrier to transport such cargo. So again, uh, the the ruling is no, but it must be distinguished from a TNVS or a transportation network vehicle service such as ANCAS. So let's go now to that case of LTFRB versus Valenzuela. So does ANCAS merely provide private contractual arrangements? In that case, this is actually not the primary issue, but the primary issue there is the preliminary injunction sa pag-require ng LTFRB of CPC, I think, of Certificate of Public Convenience with ANCAS, or there's a company name DBDOOYC. But then the question there is, does it provide contract private arrangements? So yung argument ng ANCAS is that ang ANCAS biker, hindi niya ino-offer ito sa public, sa indefinite public, but only to those who are online sa kanilang app. So, DBDOYC may not compel an ANCAS driver to pick up a potential passenger. There is but a purely private contractual arrangement. So, anong sabi ng Supreme Court? Yung DBDOYC na as a company itself is a booking agent because it only connects. So it's a TNC, Transportation Network Company. But then the court said na the law does not distinguish general public to a certain to the indefinite public, but it can include a narrow segment of the population. The fact that its drivers are not physically hailed on the street does not automatically render ANCAS accredited drivers as private carriers. So the fact na hindi sila lumalabas dyan at nagpapara like the old school style, then it doesn't make them private carriers. In fact, may mga iba nga nagtatambay sila sa mga congested places so that there are a lot of passengers nearby, right? So, there is no contractual discretion between the ANCAS bikers and would-be passengers because the app automatically pairs them based on algorithmic procedures. So, yes, walang contractual discretion sa between ANCAS and passengers, pero yung technology na mismo yung nag-prepare. Okay? But it doesn't make them private. According to ANCAS, its drivers may refuse by going offline. Okay? But the court said the fact that you go online is already equivalent to making yourself or holding out yourself publicly. So that's what the court said. Still, they may do login, they make services publicly available, as in the case of making a. So, what was implied in that case is that the transportation network vehicle services, such as the person driving the motorcycles under ANCAS, are common carriers. These persons are the ones liable to exercise extraordinary diligence, and the TNC, such as the ANCAS Corporation, is not. In that case, ANCAS argued that it is a mere tool that links passengers and motorcycles. Therefore, LTFRB and DOTR have no jurisdiction over them. So, argument ng ANCAS Corporation is that ano lang naman siya, tool lang naman siya, tagapag-connect, just like a freight forwarder. Kino-connect lang ng freight forwarder yung shipper tsaka yung receiver or consignee, and then separate na yung common carrier. So it is therefore not subject to any regulation by existing laws. In that case, kaya medyo implied siya kasi the ruling is that the Supreme Court ordered the RTC to conduct further proceedings to resolve the main petition, and that is the question as regards the preliminary injunction. So in this case, motorcycles hold out themselves to the indefinite public through the app. So we can extract from this, what we can extract from this ruling is that the angkas drivers themselves are the ones who are considered as common carriers. So this is the case of LTFRB versus Valenzuela. So now, after we have classified or have the nuances under the common carrier classifications, let's go now to the liabilities. Question: how should common carriers transport goods or passengers? The answer is by extraordinary diligence because of the nature of their business and the reasons of public policy according to all circumstances of each case. So again, the emphasis here is extraordinary diligence. Hindi siya ordinary, and we will define later on what is extraordinary diligence. So it is, kumbaga, the keyword also is utmost diligence required of very cautious persons. Okay? And then next question is, which carrier can exempt itself from liability due to negligence of its employees? So di ba may dalawa? So ano yung carrier na hindi required? Private carriers. Yes, because the public is not involved. So hindi niya hino-hold out yung kanyang sarili sa public. But for common carriers, it cannot escape liability for the negligence of its employee. So kung private carrier ka and may employee ka na nag-exercise or nakakommit ng injury against another person, so what is liable is not you as the private owner but the driver himself. But if it's a common carrier, ikaw na person or entity will be liable for the negligence. Next question: what can be the basis of injured employees against a bus company who chartered its bus for use of a single party? So again, this is a common carrier na chinarter or hinire ang kanyang bus by a single party. So na-injure yung mga passengers. So the basis is culpa aquiliana or quasi-delict, though not a contract of common carrier. So magkaiba. Yung basis or cause of action ng culpa aquiliana is negligence, while the basis for the contract of common carrier is the mere failure to perform the terms and conditions of the contract, which is to deliver the cargo or passengers to their destination. Question: is a certificate of public convenience required for a person to be held liable under provisions on common carriers? So kailangan ba may CPC? No. To exempt a person because of that mere failure is offensive to sound public policy. That would reward a party who precisely failed to comply with statutory requirements. So this is according to one case. So again, the mere failure does not exempt you from becoming classified as a common carrier. Question: when is negligence on the part of common carriers presumed? Simple answer: if there is an injury or death on the part of the passenger. So again, pag may common carrier, may passenger or may cargo. And if there's injury, if there's death, if there's damage, loss, and liability, then there's presumed negligence. Question: how can the common carrier escape from liability? Answer: that despite exercising extraordinary diligence, the collision could not have been avoided. So dapat ma-prove. You have the burden of proof kasi nasa sa'yo yung burden kasi may presumed negligence ka. So you have the duty to overcome or overturn that presumption. Question: what are examples where the Supreme Court held that the common carrier did not exercise extraordinary diligence? So, isa-isa natin that the ship was not in a seaworthy condition. Number 2, did not install radar to navigate safely. Number 3, proof of delivery to common carrier of cargoes in good order, and proof of delivery that they were released in bad order. Driver, number 4, driver was driving fast in a narrow highway and on a bridge. Number 5, common carrier did not ensure the identity of the recipients. Okay, this was in the case where the ones who received had presented falsified documents. Number 6, the loss, deterioration, or destruction was not attended by irresistible threat, violence, or intimidation, or providing security for cargo and failing to take out insurance in the shipment's value. And last, ship officer failed to send an SOS or save our ship message. Question: who is liable in case of breach of contract of carrier? Operator, owner, carrier, or driver, or both? So the answer is, it depends. If the cause of action is breach of contract of carriage, it is the operator, because the contract is not between the driver and the passenger, but between the carrier and the passenger. The driver because cannot be held liable because he is not a party to a contract of carriage. Again, what is a common carrier? It is the person or entity or corporation who holds out itself to the public its services, which is to transport goods or passengers in exchange of compensation. Can the driver of a common carrier be sued? Answer is yes, but only on the basis of quasi-delict and or criminal negligence if his negligence can be established. So hindi liable yung driver under contract of carriage, but he can be liable on the basis of quasi-delict. Or what is a quasi-delict? Question: it is an act or omission that causes damage to another, there being fault or negligence or culpa without pre-existing contractual relationship between the parties. So yung kasalanan ng driver is nakadamage siya because of negligence, okay? And without pre-existing contractual relationship. So that's quasi-delict. And before we move to the next question, again, what is negligence? Negligence is failure to conform to a standard behavior established by the society to protect society from unreasonable risk. Next question: are common carriers liable even if they exercised ordinary diligence and care? The answer is yes, because they are bound to exercise extraordinary diligence or to transport passengers or cargoes as far as human care and foresight can provide, using utmost diligence of very cautious persons with regard to all circumstances. So this is actually the definition of extraordinary diligence: to provide care as far as human care and foresight is concerned, with utmost diligence of with very cautious persons with regard to all circumstances. Next, is the presumption of negligence limited only to death or injury to passengers? Yun lang ba? Magkakaroon na ng presumption? No, because it applies to the following cases. Number one, pag hindi nakaboard yung passenger despite being given boarding pass and ticket. Okay? Because the action is a breach of contract, there is no need to prove that a common carrier is negligent. The only thing to prove is that the non-performance of the obligations under the contract. Another example, if that there is presumption of negligence, is when the common carrier downgraded the passengers' accommodation from first class to economy. And in an interesting case, it's also negligence kung in-upgrade naman ng common carrier yung kanyang accommodation from lower class to a higher class. And then, that's actually the case of Cathay Pacific versus Vasquez. Next, the last is discourtesy or rude conduct of employee towards the passenger. The court said that there is presumption of negligence and therefore the common carrier is liable for damages. Next question: what is the quantum of evidence to prove failure of exercising extraordinary diligence? So since this is a civil case, then the quantum of evidence is preponderance of evidence. Let's go to subsection 2, vigilance over goods. So parang tinouch na rin natin in some way yung vigilance over goods. But let's go in more details. So in one case, what or when does the extraordinary responsibility of the common carrier begins and ends? So when does it begin? When the goods are unconditionally placed in the possession of the common carrier. So placed in the possession. It ends when the goods are delivered to the consignee or in the person with authority to receive them, without prejudice to 17 1738. Okay. So without prejudice to 1738, ano ba ang 1738? It is that the extraordinary liability of a common carrier does not end even when the goods are stored in a warehouse of the carrier in the place of destination until the consignee has been advised and had a reasonable opportunity to remove them. So again, like common carrier ka, syempre pagdating mo doon sa port, hindi yan agad-agad kukunin ng consignee o receiver. You may sometimes place it in the warehouse. That's why napakaraming warehouse sa mga pier. So the extraordinary diligence obligation does not end there. It ends when the consignee has been advised and had the opportunity to remove them. So in-advise mo na, for example, at hindi sila at meron ng opportunity, for example, clear skies, wala namang force majeure, they all had the time and the opportunity pero hindi pa rin nila kinuha, then from this definition by the law, the common carrier is now absolved from its obligation to not exercise extraordinary diligence. And in case of loss, deterioration, or damage, it is not liable. So here's a reminder about extraordinary diligence or diligence. His master replied, "Well done, good and faithful servant. You have been faithful with a few things. I will now put you in charge of many things. Come and share your master's happiness." So in this verse, yung synonymous sa diligence is being faithful even with few things, because if you are, then you will be promoted. You will be entrusted with greater things. So that's a reminder that we are to exercise diligence in our conducts. Next, is the mere issuance of a bill of lading sufficient to bind the carrier? In that case, Kompanya Maritima inisyuhan so yung goods ay dinala ng shipper sa carrier, sa ship, and then umisyo ng bill of lading yung carrier pero hindi pa totally na-deliver, hindi pa actually na-deliver yung goods. Okay, the answer is no. Okay, wait lang. It is the actual delivery or constructive delivery and acceptance by the carrier that will bind the carrier. Okay. Next, is the receipt by the lighters free of charge, arrastre operator, sufficient to establish receipt of the goods? This case, Westwind versus UCPB, yung lighters, yung mga, di ba, pag cargo ship, for example, sa mga pier, may mga pier kasi na yung dagat medyo hindi siya ganun kalalim, so the court may use the port's lighters. Okay, so like may mga cases na may na-damage dahil sa conducts ng lighters. So the court said na kahit na-receive pa lang ito ng lighters at hindi yung main common carrier mismo, yes, the duty of care of cargo is non-delegable and the carrier is responsible for the acts of the master. So yung master, it could be the lighters or the arrastre. Common carrier has custody during unloading. So yung arrastre naman could be the one who unloads, or any entity na mag-unload ng cargo from the ship to the pier. So meron pa ring control or custody yung common carrier sa arrastre operator, yung lighter. Okay? Next, what if the goods were turned over to unauthorized persons who presented falsified documents? This is an interesting case. This happened from the Philippines to Panama. And then nung pagdating sa Panama, may mga bogus na nag-claim ng cargo. And then yung totoong consignee ay syempre nagreklamo. So is the common carrier liable? Yes. The fact that shipments were not delivered to consignee as stated in the bill of lading means misdelivery. So, nasa bill of lading yung determination kung sino talaga yung consignee. Here, there is no proof that Ned Lloyd prevented unauthorized withdrawal from Panamanian authority. So, ang conduct na nire-require ang extraordinary diligence also includes the obligation to ascertain yung identity ng receiver. It could have asked IDs, and kaya lang sa case na to, they presented IDs eh. So, hindi pala sufficient that you will just receive the ID and check the name. You should also notify the true consignee, for example, the contact number stated therein when the goods arrive. And also, well, probably you can double check under the name of the state or the Coast Guard, for example, double check. So that's in the case of Ned Lloyd versus Glolax. Next, does a common carrier obligation ceases when the goods are turned over to custom authorities? So, yung kanina, they were turned over to unauthorized persons. How about na turn over na sa customs? Yes. The answer is yes. A common carrier cannot exercise dominion over government authorities. Wala siyang custody. So, kanina, like sa arrastre, like sa lighters, may custody yung common carrier. But sa customs, mas mataas yan. So, it's subordinate to the government. Next, it would be unfair to hold a common carrier responsible for what may happen during the interregnum. So, syempre, pag customs na yung kumakausap sa'yo, and then kinuha niya, there's already the cessation of that obligation. Carrier loses control because of a competent authority or regulation. That's Ludo Corp versus LVB Namira. Question, when is a bus company liable for the loss of maleta? Okay, again, when does the liability commences? When the cargo was deposited to the common carrier for transportation. Declaration is not an element of the commencement of its liability to exercise extraordinary diligence. So the moment na dineposit yan sa common carrier, the moment na nasa possession na yan ng common carrier, that obligation by the common carrier to exercise extraordinary diligence starts. Question. Proof of delivery in good condition must be paired with what to establish prima facie case of negligence against a common carrier? So, proof of delivery must be paired with, so, kunwari may goods, and then common carrier is negligent, so sinabi ng shipper, oh, this is the proof that it's received by the common carrier in good condition. Ano dapat yung pair? Yung pair niya is proof of arrival in bad order. So once you have that proof of arrival in bad order, maybe the one who received it acknowledge that it is in bad condition, let's say yung consignee, i-check. So dapat pag ikaw yung consignee o receiver and ikaw yung nag-ship, i-make sure mo man, did you receive that in good condition? Because if the consignee testifies it's not, then that's a prima facie case. And if it's a prima facie case, the burden now shifts to the common carrier to prove the absence of negligence, and it exercises extraordinary diligence. Question, when is the obligation of the common carrier reduced to ordinary diligence? So the answer is when the seller exercised the right of stoppage in transitu, and there's stipulation for such. And then also for hand-carried baggage, Article 1754. Ordinary diligence lang kasi nasa kamay na rin naman ng passenger. But if it is a checked-in baggage, it requires extraordinary diligence to forestall the loss in case of faulty nature of goods or packaging. Okay, so nasa when the stop, and then agreement, and then passenger, and then kasalanan din ng passenger or ng contents ng kanyang or packaging ng kanyang dala. Alright, so let's go now to delay. So in relation to delay, when should a common carrier deliver the goods so that we will determine if there is delay? The answer is within reasonable time. Okay, that's the general answer. If there's no special contract, the exception is if there's a special contract, let's say a specific date, hindi to data, sorry. If there's a specific date of delivery or if there's indemnity in case of delay. So, syempre mas mahal pag may specific date. You promise, kasi you promise and then you will indemnify. But the general answer is within reasonable time. So what is reasonable time? I think in the case of Maersk versus Court of Appeals, yung may mga times na like ma-expire na yung cargo na hindi na kumbaga totally unusable na siya ng consignee, and then let's say in 4 months delay, something like that. So that's no longer reasonable. Next, what are exempting causes available for the common carriers in case of loss, destruction, or deterioration of the goods? I put a green color here because this is a common question, so it's good that if you that you memorize this. Article 1734. Generally, these are called force majeure. So na ito. Tandaan lang yung categories ng answer dito ay nature, so that's natural calamities. Enumerate natin yan mamaya, which includes flood and earthquakes. And then next is mga tao naman. So number 1 is kalaban, and then number 2 is gobyerno. So acts of public enemies, and then number 2, acts of competent authority or public authority. And the next 2 are acts or those that are under the obligation of the shipper. So acts of the shipper of the goods, may kasalanan siya. And next is the condition or character of the goods or defect in the packaging of containers. So yung laman at yung naglalaman. So these are the defenses that pwedeng gamitin ng common carrier. In the event of these 5 things, how can the common carrier not be presumed negligence? So hindi lang enough na existing, for example, yung natural calamities. Kasi bumaha. Kasi may giyera. Kasi ganito, yung packaging, sira-sira. Kailangan ding i-prove ng common carrier na it exercised extraordinary diligence. So how is that? For example, sa packaging, defective pala yung packaging. Pero the common carrier must prove na hindi niya nakita by the usual circumstances. Kunwari, it looks like a plastic, it looks like a steel, pero for them at that moment of inspection, okay siya. But yun pala, chemically, the chemical component there is having issues. So yun, doon na ma-prove na may extraordinary diligence si common carrier. Thus, this extraordinary diligence requirement stops when the goods are temporarily stored in transito. The answer is no. Kasi unless the shipper has made use of the right of stoppage in transito, kunwari pinastop niya na in transit. So yung shipper lang mismo ang may authority to put a stop once the voyage has started by land, sea, or air. So pag hindi niya to pinastop, extraordinary diligence does not stop also. So kunwari na flatan yung bus. So kunwari na karoon ng problem sa machine. So dapat i-exercise pa rin ng common carrier. Hindi niya pwedeng gamitin yung excuse na na-divert yung kanyang route, ganon. So temporary loading or storage obligation of common carriers remain in full force. So kunwari may multiple stops. So from Bacolod to Mindanao, nag-stop pa sa Iloilo, nag-stop pa sa Cebu. So the fact na may mga stops doon, hindi nagsa-stop yung obligation niya to exercise extraordinary diligence. So isa-isahin natin. Natural calamities. What are the examples or the items under natural calamities? So 4. Storm, flood, okay, lightning, and earthquake. Okay. So these are the 4. How about fire? Sunog. Does that exempt a common carrier from liability? The answer is no, because it is not among the enumerations of 1734. It can be prevented by human intervention. It can be prevented. Okay. Are monsoons considered as storms? The answer is, in one case, no, because they can be foreseen. So again, the definition of force majeure are things that are unforeseen or those that are foreseen but cannot be prevented. And in one case, it was coupled by improper stowage. Hence, the defense of force majeure is unavailing. Next, is hijacking force majeure? The answer is qualified, no? If proven that it was attended by threat, violence, or irresistible force. So pag pwede naman ma-address, pwede naman matanggihan, then hijacking cannot be used as an excuse for the exercise of extraordinary diligence. That's in one case. How can a common carrier be absolved from liability arising from force majeure? So, again, dapat may proof na nag-exercise siya ng extraordinary diligence. So, pag may hijacking, wala siyang magagawa talaga. Pag may flood, ginawa niya lahat. Nagkaroon siya ng insurance. No? Yan din pala. Pag sumakay ka sa isang common carrier, make sure din na may insurance. Kasi that's a proof of extraordinary diligence. Or, if there's a stipulation limiting the liability to a degree less than extraordinary diligence, but it cannot be lower than ordinary diligence or the diligence of a good father of the family. Next, how can the common carrier be exempted from responsibility in case of natural disaster? Okay, so, in case of natural disaster, ano yung dapat i-prove ng common carrier? First, ang proximate cause must be the natural disaster or acts of public enemy. And then, so hindi lang proximate cause, but the only cause. Okay, letter P and letter O. And then letter C, number 3, the common carrier exercise extraordinary diligence. So, POE. So, kailangan ma-prove din to na ginawa niya ang lahat, that as far as human foresight is concerned of very cautious persons, they have tried to prevent such loss. And last but not important, the common carrier is on schedule. Okay, on schedule. So para hindi ka maging liable as a common carrier for natural disasters, it must be the proximate cause. So what is proximate cause? That in the natural and continuous sequence of events, unbroken by any efficient intervening cause, produces injury, and without which the result would not have occurred. When is the common carrier absolutely liable in case of loss, deterioration, or damage caused by natural disaster? Also, if the common carrier incurs delay in transporting the goods. So, kahit ito po yung proximate cause, only cause, at nag-exercise pa siya ng extraordinary diligence, pag nasa delay siya, if it's in delay, common carrier is still liable. Let's go now to the public enemy. So, what is a public enemy? It is a citizen or of a country in which the Philippines is at war. Okay, so magiging defense ito ng common carrier pag ginawa ito kung kunwari may giyera na tayo sa isang country. Let's say we are at war with Avail, for example, and then Avail attacked the cargo ship. So, hindi liable si common carrier kasi at war tayo. That's why never go to war kasi walang sasagot ng mga damages pag nagkaroon man. Next, acts or omission of the shipper. So, pag may kasalanan yung nagpadala, syempre, yung may kasalanan, magbabayad din. When is there equitable reduction? So, the term there is when there's contributory negligence. So, ano yan? It's on the part of the shipper. But the proximate cause of the LDD, loss, destruction, deterioration, is on the part of the common carrier. So, kung may establish mo na may contributory negligence, pero meron ka pa ring negligence, still, hindi yan total absolution. That is only reduction. Okay? That's according to an article. What if the shipper or owner merely contributed to the loss, deterioration, or destruction of the goods, but the proximate cause, again, yan yung answer kanina, equitable reduction lang. Okay, hindi siya total excuse, total absolution from liability. Question, when will the carrier be absolutely liable for loss, destruction, or deterioration of the goods despite defect in packing? Kailan maging liable kahit defective na yung packaging? So, kunwari ako yung shipper, binigay ko sa iyo as a common carrier, paano ka still maging liable kahit sira-sira yung packaging? Kung nakita mo na if it's known or apparent to the carrier upon ordinary observations, but the carrier still accepts the goods. So, alam mo na ngang sira, alam mo na ngang may red flag, alam mo na ngang masisira yan, tinanggap mo pa rin. Eh di nasira nga, eh di ngayon liable ka. So, meron din tayong principle of assumption of risk. Or alam mo na, nakita mo na yung mali, pero wala ka pa rin ginawa. So, dapat may ka rin, self-worth. No? Kumaga, may self-preservation ka rin. Self-respect. Love others, but don't forget, the Lord commands, as you love yourself. Okay, of course, love God above all. Southern Lines versus CA. So now, the pertinent question is, ano ba yung loss? Just a review lang to as a civil review. What is loss? Loss can be three things. Physical, legal, or civil loss. Ano yung physical loss? When the thing perishes, or physical loss, like for example, when the house is burned. Yung civil loss, yan naman yung nawala at hindi na alam kung saan na to natagpuan. Okay, that could be a person that has been presumed dead. Or, alam naman yung kanyang sitwasyon, alam naman kung nasaan siya, pero hindi siya marirecover. Kunwari, yung sa Titanic, alam naman kung saan yung nahulog sa dagat, pero hindi na ma-recover. Hindi kaya na, ano kaya yung example ng, alam mo kung nasaan siya, pero hindi mo na siya makuha. Yung mga ganyan. Ano kaya yung sitwasyon yan, no? So, I don't know, kayo lang nakakaalam niya, no? Alam mo na kung saan siya, pero game over na. Okay. Legal loss, yan naman pag nasa out of commerce na siya, or when it is legal before and it becomes illegal. So now, nawala na siya kasi illegal na eh. Hindi na pwedeng angkinin kasi pag inangkin mo, ikaw ay guilty ng possession of an illegal item. So wag mo nang angkinin pag illegal lang angkinin, no? Character of the goods. What's character of the goods? How can a common carrier be exempt from liability if the loss was due to character of goods or faulty nature of containers? So, paano kasalanan pa rin ng common carrier kahit sira-sira yung pinadala ko? So, how can he be exempt? So, let's say sira-sira. So, when he exercised due diligence to forestall or lessen the loss. So, kunwari, with assumption to na hindi niya alam na faulty pala yung containers or yung goods. So, yung ginawa niya pa rin ang lahat ng makakaya niya to prevent loss. So, therefore, in that case, he is not liable. Now, let's go to competent public authority. How can a common carrier be held liable despite an order of a public authority? So, di ba sinabi natin kanina, hindi under the control ng common carrier yung authority, yung government authority. Pero paano siya maging still liable? Pag ang authority ay walang power to issue such order. So, pwede na may authority siya, pero yung nilabas niyang order ay walang kapangyarihan, hindi under his authority. So, that's under Article 1743. Municipal officials ordered the common carrier to dump the cargo to the sea. So, this is in one case. So, sabi ng common carrier, sinabi sa akin ng government official na yan na itapon ko daw sa dagat. So, is the common carrier still liable? So, lahat na lang ba susundin natin? Lahat na lang ba ng sinasabi ng nasa taas dapat nating sundin? The answer is no. Therefore, if sinunod niya, he is liable. So, in that case, he was liable because the order was illegal. So, make sure na nasa competent authority and also make sure na yung order mismo is competent or legal. And then, no proof that such order was issued with force, threat, or violence. This is also important. Na kahit illegal, pwedeng ma-absolve. Kung illegal, pero may threat. Pero kung walang threat, you will be liable. So, as much as you can, kung wala naman lang threat, mag-resist ka. Kung walang panganib, kung walang force, kung hindi ka man lang in-intimidate, at ginawan ka ng bagay na hindi magbuti, just resist. No? Mere difficulty does not mean force majeure. Hindi excuse yung nahihirapan tayo. So, komo mahirap, ayaw mo na. No? So, dapat, yun talaga, may force, threat, or violence. This is the case of Ganzon versus CA. So, the next question, can a common carrier stipulate the degree of vigilance to less than extraordinary diligence? So, di ba diyan yung default? Yung default ng law is extraordinary diligence or ED. The answer is yes. provided the following are met. So since it's a contract, first it must be in writing, signed by the shipper or owner. Okay, and then of course with a common carrier. Again, in writing, kasi the basic principle that the memory of man cannot be trusted. So syempre para walang away, ito may kasulatan. Second, since it is a contract, there must be consideration. Bakit ginawa yan? Bakit baba yung requirement ni common carrier? Well, the obvious reason could be so that the payment of the fees would be lower, or maybe the insurance cost or the payment in case of damage would be lower. So experience nyo yan pag magpadala kayo, like for example sa fast craft. So tatanungin kayo ng receptionist, magkano to ang value nito? Kasi pag mataas yung value, it could be na higher din yung payment, or tatanungin ka ay yung anong laman. Kasi for example, pag ang laman yan ay laptop for example, so syempre mas mahal yan. So it would require extraordinary diligence of course, or maybe higher. But then if sinabi mo, I want to pay less, maybe mga ano lang to, mga bato or some example, or mga not so valuable things. And then but I want to pay less and then bulk. So you would sign a contract. Consideration, and then last would be reasonable, not contrary to public policy. So ano yung mga contracts na contrary to public policy? What are these? For example, the Transpo is at the risk of the owner of the goods. Common carrier is not liable for any loss, damage, or deterioration. So hindi pwede na wala talagang liability yan, kasi that public will suffer. Wala nang accountability yan. This will be a world with chaos, no? Kung wala accountability. Number 3, CC need not observe any diligence or lower than ordinary diligence. So hindi pwedeng lower. And then number 4, CC is not liable for any defect in their vehicle. So that's contrary. That's an outrage, kasi sa'yo yan obligasyon mo yan no? So dapat you make sure that it is in good running condition. 5, CC is not liable for acts of thieves who do not act with irresistible threat, force, or violence. So responsible talaga yan. What are the valid stipulations limiting the common carrier's liability? Number 1 is delay or rerouting with just cause. Okay, or delay with reasonable cause, walang liability yung common carrier. Number 2, delay on account of strikes or riots. Number 3, limited to the value declared in the bill of lading, or a contract fixing the recoverable sum. So, ito valid ito kasi nga kung ano yung dineclare mo, yan lang yung babayaran ng insurance, for example. That would be the basis of the insurable amount. Or a contract of the recoverable sum. Pwedeng ma-stipulate yan, papadala ko tong mga medicines na to sa inyo. Under this contract, na pag nawala, na damage, ganito yung babayaran. So that could be valid. Okay? What shall be considered in determining the stipulation limiting the common carrier's liability? So ano yung dapat? The fact that the common carrier has no competitor. Article 1751. So pag walang competitor, asahan din na wala ring mas kumbaga pwede, kasi pag walang competitor hindi siya mag-exercise ng diligence kasi walang aagaw ng benta. So hindi pwede yan. That could be against the public policy. Next, even if there is a limiting contract, what shall be deemed of the common carrier in case of loss, deterioration, or destruction? Common carrier shall be deemed negligent. So again, that's basic. In foreign shippings, what law shall govern in case there is LDD? Foreign shipping sa destination is outside the country. The law shall be governed by the law of the country of destinations. Next, stipulations for limiting liability. So, limiting liability meaning ililimit ng common carrier yung degree of diligence niya or yung kanyang liability in case of loss, damage, or destruction. So, paano yan? Or how can it be done? Are passengers bound by the venue stipulations in the ticket? So, ito naman, stipulation inside the ticket. So, pag bumili ka, nandun na lahat. No? Nakasulat. So, bound by yung passengers? The answer is no. The court said that it is not fair to bind the passengers in fine letter at the back of tickets because there is no reasonable opportunity for them to examine the condition. CPC holders or Certificate of Public Convenience have monopoly and can dictate conditions. So going back to contracts, what kind of contract is this? Yung nasa ticket, that's a contract of adhesion. So napaka-fine print, kunwari napakadami ng babasahin, you just click accept, right? You just click buy. And then it subverts public policy in limiting venue because of the innumerable passengers. The expense for those who reside from the stipulated venue will discourage injured parties to file at all. So kunwari sinabi diyan sa ticket, lahat ng actions ipa-file lang sa Dagupan or sa Cebu City. That is against public policy. What if yung passenger nasa Samar, nasa Negros, no? So that would discourage them from filing kasi yung venue nandun lang sa Cebu. So this is Sweet Lines versus Honorable Teves. So still with stipulation, so again, pwedeng malimit yung liability ng common carrier, but pwede ba na ma-fix yung amount? Valid ba to? The answer is yes if it's reasonable and just under circumstances and has been fairly agreed upon. So number 1, fair, and number 2 is agreed. So kailangan, for example, nagpadala ka ng laptop, no? And then you agreed and then you stipulated there na as the shipper, ilalagay ko to sa kamay ng common carrier at in case of loss of this laptop, in case of loss of this device or deterioration or damage to this device, yung liability ni common carrier for example is 30,000. Kahit yung laptop, let's say, is MacBook, nasa 65,000-75,000. So, pwede ba yon? Number 1, yes, if it's reasonable. So, maybe 30,000 kasi sure ka naman. May trust ka naman sa kanya. No? Alam mo naman na may trustworthy siya. So, kaya medyo mababa lang. Pag wala kang trust, edi syempre taasan mo. Pero pag may trust, syempre, hindi naman gaano kagagastos ng malaki kasi malaki din yung fee usually pag malaki yung fixed amount. So that's why pag trustworthy ka, hindi ka high maintenance, no? Pero pag hindi trustworthy, syempre mag-overthink ka, di ba? Lagi kang na-anxiety diyan. So that's the logic. Next, what if the shipper did not disclose the true value of his goods? What is the limit of the common carrier's liability as to the value of the goods? So let's say nagpadala ka ng package. So usually chine-check yan o usually tinatanong yan kung ano ang laman. So let's say but sinabi mo lang ganito pero actually valuable pala yan. Let's say sabi mo crystals lang kaya pala totoong diamond. Parang ganon. So ano yung how will the common carrier be liable? It only what is stated in the contract of carriage. So, nasa lang, kung ano lang yung dineclare dyan. No? So, let's say, yung tinanong ka, ma'am, yung magkano yung glass na to, yung crystal na to, sinabi mo lang, 3,000. So, that is the only limit of the common carrier. Eastern versus Australian steamship. Next question. What is the basis of the liability of the common carrier for the worth of its cargo? The answer is, what is declared in the bill of lading. Okay? Sa common carrier, nasa bill of lading or the contract of carriage. So, bill of lading, yun yung threefold contract. So, just to recall, a bill of lading is the document issued by the common carrier to the shipper. So kung ako yung common carrier, ito yung pinadala mo sa akin ha, it will state that I received the goods. So it serves threefold purposes. So I received your goods. So that means nasa sa akin na yung possession, I acquired possession of it, and I am responsible for it to exercise extraordinary diligence. Number two, it serves as a contract of carriage. It represents the contract between the shipper and the carrier for the transport of goods, the terms and conditions, and the details. So, nandyan yan kung I will exercise extraordinary diligence or we have agreed to a lower kind of or to a lesser kind of diligence. So that itemizes those things. And title document, it serves as a document of title to the goods, enabling the transfer of ownership by endorsement and delivery of the bill. So kung that the ownership is the title transfer. So once that the bill of lading is endorsed or delivered to the consignee, yung title nasa consignee na. So that is also a title document. So that is important in international trade where the goods might be sold several times during the transit. So possible yan, sinusold doon sa port B, sinesell sa port C. So that could be possible. So that's the bill of lading. And the bill of lading must contain the description, value, and freight charges. Otherwise, the common carrier is only liable for what is stated in the COGSA. COGSA for international destinations. Okay? Carriage of Goods at Sea Act. So there must be the statement of the value in the bill of lading or the legal document between carrier and the shipper, detailing the obligations of the parties. Question: when is the common carrier bound to pay a higher amount for lost baggage? If the passenger declared a higher value, otherwise he is bound by the value in the ticket. So again, common sense, pag may valuable item ka na pinadala mo, dapat i-declare mo talaga na may valuable item ka. Otherwise, yung nasa ticket lang o nasa insurance lang na stipulated under the ticket. Okay? What is the liability of common carriers for baggage of passengers? So, pag let's say nag-check-in ka or pumunta ka nagsakmay ka ng aeroplano, may bag ka, syempre may maleta ka, may shoulder bag ka. So ano yung sinakyan mong aeroplano, ano yung kanilang obligation dyan? So we have to distinguish. First, yung chinek-in mo, extraordinary diligence yan. Okay, lost is equal to presumption of negligence. Bakit? Kasi yung possession and control is transferred the moment na nilagyan niya ng sticker ng paglating mo sa airport and then nilagay yan sa parang conveyor belt. That already goes to the possession of the common carrier and they should exercise extraordinary diligence. And for hand-carried baggage, it's only ordinary diligence. Common carrier is only liable as depositary provided that notice is given to the common carrier and common carrier advise passenger to be vigilant over his baggage. So yung hand carry, minsan yung dinadala natin inside the plane, yung nilalagay natin overhead, yung obligation dyan is only ordinary diligence. Kasi number one, nasa kamay mo rin naman. Okay? They are only required to exercise ordinary diligence. Loss due to passenger's fault, common carrier is not liable. So, unlike sa extraordinary diligence, presumed negligence. Pero pag nawala, na nasa sayo naman, yung hand carry mo naman, nawala yan, at wala namang fault yung common carrier, sa'yo yan. They are not liable. Question: what rule governs in case of loss of hand-carried baggage? The rules on necessary deposits. Common carrier is liable due to loss caused by its employees or by strangers within its premises. So again, the rule on necessary deposits, pag cost yan ng steward, for example, yun ng flight attendant, then they are liable. Or by strangers within its premises, then they are liable. Okay? Pero pag wala mo yan, let's say, hand-carry mo, but lumakad pa kayo from the terminal to the plane, na wala mo siya along the highway or along the way or along the bus or somewhere, or maybe not within the bus but maybe somewhere nag-CR ka sa terminal. So hindi niyan kasalanan ng common carrier because their obligation is governed by the rules on necessary deposit. What is the basic rule on necessary deposit? So just a review of our credit trans. The depositary is generally required to exercise a prudent level of care, keeping the deposited property safe and separate, and must return it upon the depositor's request in the condition it was received. The depositary should not use the property without permission, must notify the depositor of any issues, and may need to maintain confidentiality regarding the deposit details. So, ma-apply mo ba to sa hand carry? Yes, siguro sa pagsakay mo ng bus, for example, going to Baguio, diniposit mo siya. Usually, hindi pag hand carry mo or let's say, should not use the property without permission. Okay, so that applies. So a reminder, Luke 16:10, whoever can be trusted with very little can also be trusted with much, and whoever is dishonest with very little will also be dishonest with much. So if you have not been trustworthy in handling worldly wealth, who will trust you with the true riches? So a reminder on the necessary exercise of diligence, that it reflects the heavenly kind of if we are faithful and trustworthy in worldly wealth, how much more with the true riches? So that's the end. Thank you very much. God bless. Bye-bye.